There are two types of e-visas: the E1 visa, also known as the Treaty Trader visa, and the E2 visa, also known as the Treaty Investor visa. The Treaty Trader visa, E1, is designed for aliens who are citizens of a nation that has a signed trade treaty with the U.S., who are coming to the United States in order to carry on or engage in substantial trade between his country and the U.S. This generally means that 50% or more of the trade the foreign business conducts is with the U.S. This also includes trade in services and technology. The Treaty Investor E2 visa is designed for aliens of a nation that has a signed investment treaty with the U.S. who are coming to the United States solely to develop and direct the operations of an enterprise in which he has invested, or solely to develop and direct the operations of an enterprise in which he is actively in the process of investing a substantial amount of capital, or as an employee who will perform services that require special qualifications essential to the operation of the treaty investor's visa. The definition of substantial, with reference to the investment, is at the discretion of the U.S. government, and they generally assess whether the value of the investment is substantial as a percentage of the fair market value of the enterprise. 75% of the value of the enterprise for a smaller business, and 50% of the value of the enterprise for a business valued above $500,000. Or whether the value of the investment is substantial as a percentage of capital usually required to establish the type of business in the industry specified in the application. In addition, the investment enterprise must not be marginal, meaning it must have the capacity in the present or future to provide income more than a living wage to the investor and his family. For e-visas, it's important to have strong documentation of finances, including the source of the investment funds, the tax history of any existing entity as well as the individuals, and a detailed business plan that demonstrates the viability and growth opportunity of the business. For treaty investment visas, it's also important to show that the funds belong to the investor and they are not a gift from another party. In addition, the following three elements must exist for the e-visa to be approvable. 1, there must be a treaty between the U.S. and the country of the company and that of the national applying for the visa. 2, the majority ownership or control of the enterprise engaged in trade or investment with the U.S. must be held by nationals from the country which has the trade or investment treaty. Each employee or principal seeking e-status must hold citizenship of the country which has the signed trade or investment treaty. There is a premium processing option for e-visa petitions filed in the United States. For an additional filing fee, the U.S. Immigration Service will commit to process the application within 15 business days from the receipt of the application. Generally, e-visas are granted for a period of 2 to 5 years, and the initial period can be extended indefinitely. The spouses and unmarried children under 21 of e-visa holders can obtain a derivative e-visa and may live and study in the United States without any additional permits. In addition, the spouse of an e-visa holder may obtain work authorization in the United States. For more information and a list of documents required for an e-visa, please visit us on the web at FitzGeraldImmigration.com. If you would like to obtain legal help from one of our e-visa immigration lawyers in preparing your e-visa petition, please contact our office to make an appointment at 617-303-0006, and we will be happy to help you.